Case 118366, State of Kansas versus Thad C. Green.
May it please the court, Peter Meharry for Thad Green. I could reserve 3 minutes of my time for rebuttal, Your Honor.
3 minutes is reserved. Thank you.
Thank you. In this case, my client was convicted of 1 count of murder in the first degree, aggravated burglary, and arson. Those charges arose out of an incident that happened in late December 2015. The state's allegations are that my client traveled from his home in Oklahoma to rural Montgomery County, Kansas, where the boyfriend of my client's ex-wife lived. The state alleges that my client then broke in and shot the victim in this case, and then set the house on fire. The cause of death was gunshot wounds, and as a result of that, the jury did convict my client of those 3 charges: murder 1, aggravated burglary, and arson, and he was sentenced to a hard 50 plus 53 months incarceration. We've raised several issues in our brief. I'd like to start with the first issue, which deals with the district court's denial of my client's request for a voluntary intoxication defense. As this court certainly knows, 2 questions come when you ask for instructions, and that is whether or not it's factually appropriate and whether or not it's legally appropriate. Voluntary intoxication certainly would be legally appropriate, as it would be a defense to the specific intent crimes of murder 1 and aggravated burglary. The question, and I think what the district court found, was that there was not sufficient evidence for such an instruction.
Mr. Meharry, this case is a little peculiar in at least one way, and that is that in the 455 pretrial proceedings, the state was the one urging introduction of evidence having to do with drinking and driving on the night of the crime. Isn't that right?
That's correct.
And your side of the case, and I understand this wasn't you personally, but your side of the case was arguing not to admit that evidence.
Originally, when that evidence came up, they argued against it.
So here's my question, and it's not one-sided. I have basically the same inquiry of your opposing counsel, so she can anticipate it. And that is just that it seems to me that both sides now would like to hold the other to what they said pre-trial. But if we're going to do that, we should do it for both, not just one. Would you agree with me on that?
I would disagree with you on that, Your Honor. I think my client can fully argue this evidence should not come in. But at the same time, when the court says, yes, it's coming in, deal with it in how he or she sees appropriate. And in this case, when it comes in, his argument was, okay, the state's already argued this goes to my client's state of mind. I should get a voluntary intoxication defense.
And that leads me to my next question. And you're talking about getting a voluntary intoxication instruction, which enables a defense, just so we're clear on our terminology.
Correct.
But at any rate, that brings me to my next question, which is, was there a limiting instruction on the drinking and driving evidence?
I'd have to double check the record, Your Honor. I thought there was, but I'm not positive.
Okay, well, assuming there was, let's just assume for purposes of argument there was one, then how much more do you really get from a voluntary intoxication instruction than what you already got from a limiting instruction on the 455 evidence that said it can be considered for state of mind? Because that's what you want it considered for, right?
Certainly that's what we want it considered for, but that instruction does not go that next step and say it can be a defense. If you can't form the state of mind, the criminal intent, that's a defense to murder 1 and aggravated burglary. And the limiting instruction doesn't do that. It just says you consider it for this reason. It doesn't give the next step as to why that's important. And I think the voluntary intoxication defense does go to that and say, if you think he is intoxicated to the point where he cannot understand what he's doing, doesn't realize what he's doing, then it is a defense to those specific intent crimes.
Okay, now I have one last question, and then I'll let you make your argument. And that is, just what is your evidence here to support not just consumption, but impairment?
I think the evidence here comes from several witnesses at trial who testified that my client was very drunk on the night in question. His father testified that he had never seen him so drunk, that he was slurring his words when he talked to him, that he was suicidal, His sister also testified that she thought he was very drunk on the night in question. She went over to his house shortly after when the incident allegedly occurred, found him, she and her brother, found that he was drunk, decided to take a handgun out of the house because they're concerned of what he may do with it in that condition. They took a whiskey bottle out of his house, and they took his son out of the house because he was so drunk. They were concerned about what would happen with those things given his condition. And I think that is enough. That shows more than just consumption. That shows intoxication and impairment sufficient for the voluntary intoxication defense.
But it shows intoxication after the crime.
That is correct.
How do we move back in time to know what his level of intoxication was as he contemplated and or planned or executed the crime?
Well, I think this court can look at, okay, how drunk was he at this point? And infer, okay, that means he was probably this drunk at this point. This court allows convictions of the gravest offense on circumstantial evidence, where you have evidence and the jury can infer certain things from that evidence. This is evidence that the jury could infer that if he was drunk at 1 o'clock, that drunk at 1 o'clock, he was drunk at midnight. And I think that is something the jury should have been able to look at and consider and make that factual determination.
I think it was just after midnight, right, when the fire was detected by the neighbor.
I believe that's correct, Your Honor.
Was there ever any evidence from the fire marshal folks or any other experts about how long before that point? Because the house and car and outbuilding were all engulfed at that time, right?
Correct.
So obviously this fire started somewhere before a moment before that.
Sure.
Was there ever any testimony about how long the fire had been burning before?
I don't believe there was.
Okay.
If there was, it's not coming to my mind.
There was testimony that there was no accelerant used,
There was
right?
testimony there was no accelerant, just that
Okay.
a fire was set and it eventually consumed, as you said, the house, an outbuilding, and part of the car.
And all of that was burning when the first person saw the fire had
Correct.
happened.
It was in rural Montgomery, and a neighbor down the road saw it engulfed and called the fire.
Okay, thank you.
And I think that as far as timing goes, that's ultimately a question of fact for the jury to sift through and determine, okay, we have a fire that's reported at this time. We have him reported as drunk and impaired at this time. What does that mean? I think that's a question of fact for the jury, and that's why the voluntary intoxication instruction should have been given, allowing the jury to make that call. The second issue is also an instructional issue, and that deals with voluntary manslaughter. At trial, defense counsel requested the lesser included instruction of voluntary manslaughter.
What facts are you relying on to support that? To support the instruction that were presented? It seems pretty flimsy. It appears to be from one of the informants that once he got there, he just snapped.
Correct.
Is that just your theory of the facts that support it?
That was the testimony of one of the informants, that when my client originally went to the house, it was to, according to this informant, this is what my client told him in jail, that he went to the house to vandalize it, not do anything else. But when he got there, he just snapped and went inside.
And that's
killed
from
him.
someone who wasn't there. It's from kind of a recount of what he was told. Is that right?
He was not there, but it certainly was evidence that was admitted at trial on behalf of the state and was used to convict my client of those crimes. So I don't think we can discount it just because it's not eyewitness identification or eyewitness
Well, it's just
testimony.
speculative. It's like this might have been of what happened. I mean, there's not.
I would argue it's
Is that
not
enough?
speculative when the informant testifies, this is what my client said.
And is that enough? Is just snapping enough? Or do we have to also look at whether there was a factor, something happening in the moment that caused an instantaneous reaction?
I think
It seems like this is something that's just more that is built up over months or even longer in time, rather than what we usually have in a voluntary manslaughter case.
certainly there was a history. This was essentially, this court sees it often, a situation where the victim was the boyfriend of my client's ex-wife. And there was a turbulent history there, but the testimony at trial was when he got there, he saw the victim, and everything came to a head essentially, and he snapped. And I think that is enough for voluntary manslaughter. And I do want to point out...
Isn't the explanation for the statement that he snapped explained by other testimony that he told someone that when he got to the home that night, this was his chance to pay back the victim for what he had done. Wasn't there testimony to that effect?
I believe there was, Your Honor. I don't
Yeah.
have all of it remembered specifically, but there was testimony that everything came to a head when he got there.
There was testimony about the possible intention to vandalize.
Correct.
But I think the snapped word just came from counsel. I don't think it came from testimony.
That was, defense counsel described it that way.
Yeah.
But I
Right.
think that is an apt description of what the testimony was, because the testimony was, I got there, I saw him, everything about this relationship, all our problems in the past just came to a head, and I snapped. Even though, I'm quoting the defense attorney, I think that describes the testimony. And I do want to point out the standard for this court. And the standard is just some evidence. And I would pose the hypothetical, if the district court had instructed on voluntary manslaughter, and if the jury had convicted on voluntary manslaughter, would it be reversed for sufficiency? And I would argue this court would not. And if there's enough to sustain the conviction, there should be enough to get an instruction. And that's all we're asking for, is an instruction, so that the jury can make those calls as to whether or not this was done in the heat of passion, or whether or not this was premeditated murder.
Wouldn't your sufficiency test that you've articulated, that some of us here have articulated, basically any lesser included would pass a sufficiency test, wouldn't it?
I don't think that's necessarily the case. I mean, my point is, it seems like this court is erecting a higher bar to get an instruction than to sustain a conviction. And I don't think it's logical. And I think if you could say there is nothing here to support manslaughter, then you don't get an instruction, certainly.
Isn't that true if an element of the heat of passion crime is a precipitating event?
I guess I'm not following your question.
Well, it relates to an earlier question. Isn't one of the elements, essentially, of a heat of passion killing is a precipitating event?
Something that caused heat of passion.
Yes. And that isn't, and I don't know what the language is, I want to say isn't unreasonable, but that would cause a person to lose the ability to control themselves effectively.
What this court has said is heat of passion is essentially acting without thinking, something to cause that.
Right.
And I think we have that here.
What is that?
That is him going to that house with the intention of vandalizing
As a
it.
matter of law, can a person get a heat of passion instruction if they themselves are the ones that precipitate themselves losing control?
I think
I don't know if we have. Do we have any cases that suggest
I don't know of any off the top of my head, but I don't think this court has said it has to be a precipitating event by a third party. It just says something has to happen to make the person act without thinking, respond without, irrationally. So I don't think it's predicated on some third party essentially poking the bear. I think it can be a situation where a person...
So a person can, as a matter of law, put themselves, can essentially cause their own precipitating event to cause them to lose control.
I think people can put themselves in a position where they may be intending to do something, but they get to that point and suddenly things change in their mind and they snap. And in this case, I think that is what we have sufficient for that instruction.
I want to ask one quick follow-up question. You're out of time, and you may have a couple other points you want to hit before you sit down. Just kind of following up on Justice Rosen's question. So I can understand how it's difficult to discern when you do not get the lesser included instruction under our test, when the lesser included and the greater crime are only distinguished by one additional element in the greater. For example, first-degree murder, second-degree murder. All you have to add is pre-med. And I understand your position that doesn't add much, but intentional for second degree, intentional premeditated for first degree. But when you have a lesser included like voluntary manslaughter of the type that you're saying you should have gotten instruction here, where you have to show heat of passion or sudden quarrel, that's actually an additional element in the lesser included crime, isn't it? A different element.
It's a different
mitigating
question,
element.
certainly.
It's a different question. It mitigates that intent factor,
Correct.
right? So that really does require unique evidence to be admitted. Not just the same evidence that would support either crime, but unique evidence that demonstrates the existence of heat of passion or sudden quarrel, right?
I would agree with that.
Okay. That mitigates whatever confusion there may be in those other lesser included cases where second degree and first degree are so close, it's pretty tough call. Never mind, you don't have to answer that. I just talked to myself there.
Okay.
Thank you.
If I could just make one quick point.
Yes.
And that is, and this goes to both the first two issues and my argument on cumulative error. If you look at harmlessness, we haven't talked a lot about harmlessness, but I would point out, the state's argument is, even if these were error, we have overwhelming evidence that puts my client at the scene doing these things. But if you look at the errors in this case, what that does is takes away defenses to that strong evidence the state wants to argue. Because at trial, my client's argument was basically, it's circumstantial, you haven't proven it's me. But if the state's evidence, as they've argued, is so strong, the better defenses maybe at trial would have been voluntary intoxication or voluntary manslaughter, because that would be an argument, look, I was there, but you should find me not guilty for this reason, or you should find me guilty of the lesser. So I think the damage here is it takes away defenses, arguably even better defenses than what was left for my client at trial. And for that reason, we would ask that this court reverse and remand this case for a new trial. Thank you.
Thank you.
Good morning, may it please the court. The state appears by Assistant Solicitor General Jody Litvin. I'll go ahead and take the issues as they were presented here. I'll go ahead and hit on the first issue first, the voluntary intoxication instruction. It's the state's position here that the district court got it right, that the issue was preserved, it was legally appropriate, but it wasn't factually appropriate here. There was a limiting instruction on the 455 issue. I believe that was in instruction 18 about the defendant driving under the influence of alcohol. So there was that limiting instruction. And to go to your Honor's question about holding both to what they said at the pretrial, I think the state did here. And the opportunity for the defendant to argue that a voluntary intoxication instruction was appropriate or that they were going to pursue a voluntary intoxication defense, that opportunity was had, and the defendant didn't do so. And so I think that the jury was given the correct instruction based on that pretrial ruling that they could consider it in the defendant's state of mind, and that's where it ended. And that was correct. Our position remains that there was no evidence of impairment at the time that he committed the crime. Like Your Honor was saying, we have evidence, a lot of evidence of what his intoxication was afterwards, but nothing really at the time he committed the crime. And if we go back to the defendant's interview, which is, I think, the best evidence of what his intoxication level was at that time, or near that time when he said he got at the railroad tracks, he never said that he couldn't remember. There was no confusion. He didn't have any trouble recalling any details. He said he was drinking, but sipping on it, he didn't kill his drink. So I just don't believe that there was, that the defendant met his burden to show that he was impaired at the time and it wasn't just more than mere consumption. As to the second issue, again, we would agree that it is legally appropriate as a lesser included, but not that it was factually appropriate here. And I think this court has really hit the nail on the head when in the previous discussion of where's the event, where's the sudden impulse without reflection, and what does that spray paint evidence or the evidence that he was going to go and maybe vandalize his house, where's the sudden impulse in that? Where's the heat of passion there? So we just don't believe that that's factually appropriate here. And if you look at the totality of the evidence, it really shows that this was a pre-planned murder.
Real quick, Ms.
Yes.
Lipson, was there any evidence of him having spray paint cans in his car?
I tried to go back and find
truck,
that, and I
whatever
thought
you
there
said.
was, but I can't pinpoint you to where. But I thought the prosecutor at one point said, maybe in closing argument, that there was spray paint cans in the Jeep.
Okay.
But I couldn't find that for sure in my review. But we certainly know he had a gun and a knife and a lighter. He armed himself before going over there, and whether that was his intent first to go over and vandalize the house, where was the provocation and when did that happen? Especially considering the fact that the victim was sleeping when he broke into his home. So, as I laid out in the brief, we find it hard to believe that there was any provocation when you have to break into someone's home and scream at them before you shoot them 4 times and stab them, and then decide to conceal the crime by lighting the victim and the house on fire. So if you just look at the totality of the evidence, again, I think that there is very strong evidence to support premeditation and that this was a planned murder and not a sudden quarrel, heat of passion, and that voluntary manslaughter instruction was not factually appropriate. And I'm going to keep my comments quite brief. I didn't have any other further presentation.
There are other questions. Thank you, counsel. Mr. Meharry, you reserve 3 minutes.
Just a couple quick comments. As far as the state's argument that voluntary intoxication was not argued as a defense in this case, it couldn't be argued as a defense because he didn't get the instruction. There would have been no point for defense counsel to get up there and say, my client was so drunk, so impaired, that's a defense to first-degree murder because the jury was not instructed in that regard. Secondarily, when the state talks about the evidence doesn't show this or doesn't show that, they are arguing the evidence. They are arguing the facts. And there's evidence here that could be argued the other way, and that is why we give it to a jury, for the jury to decide. At the end of the day, these are factual questions. There's evidence to support these arguments on both sides, and it's the jury's job to decide which way to go. They were not given that opportunity in this case, and for those reasons, we believe district court erred, and this warrants reversal for a new trial. Thank you.
Thank you. Thank you, counsel, for your arguments. We will now take this matter under advisement.